There he is.
He's on.
Welcome back. All right, counsel, when you're ready, Mr. Martino.
Good morning, Your Honors. May it please the court. My name is Nick Martino, and on behalf of the Public Defender's Office represents the appellant Gary Anthony Penton. And Your Honor, I'd request 4 minutes on the rebuttal.
All right.
Thank you, Your Honor. Your Honor, there's one overarching issue here, but there are two different grounds, and that overarching issue is whether Mr. Penton's defense counsel was ineffective. And I'd like to just, on the procedural front, let the court know that this post-conviction appeal originally came to the court with 5 grounds. It was remanded back to the trial court on 2 grounds for a full hearing, which did not occur. And now it's back on those same 2 grounds. So addressing those 2 grounds, and then I'll go into them specifically. The first is Mr. Penton's, what we're framing as his denial ultimately to testify on his own behalf and the misadvisement of counsel. And then the second part is the failure of counsel to interview, pursue in any way or in any significant way the testimony of his co-defendants that Mr. Penton believed would help exonerate him. Looking to that first issue of the testimony portion of this was a robbery case. And I won't belabor the facts too much, but Mr. Penton was driving around the victim in the case. And at some point during that day of driving him around, the other co-defendants, when they were separate, when Mr. Penton and the victim were separated, ultimately robbed the victim of $120. So I think it's important to note that as a part of these facts, that this case, the only evidence, the only defense that Mr. Penton had was his own potential testimony or the testimony of his co-defendants, which he believed would or could exonerate.
Wasn't Mr. Penton given the option of testifying?
No, Your Honor, he was not. And that's what that hearing really brought out.
Didn't the judge say, Mr. Penton, it's your decision if you want to testify regardless of what the attorney has told you? Wasn't there a colloquy on the record?
I'm sorry, Judge, I missed that.
No, in other words, wasn't there a colloquy on the record between the trial court and Penton where the trial court said, hey, you don't have to testify if you don't want to, but if you do, you can testify? There was a whole little colloquy.
Yes, Your Honor, I apologize. I thought you were referring to the...
He was given the option to testify, and he said, no, I don't want to testify. Then the other attorney, his attorney testified at the 3850 hearing and said what he said, and the judge said, I find your attorney credible. And they didn't find Penton credible. So what's the incompetency? I mean, you have a strategy decision. If the man testified, he would have been impeached out the wazoo, correct? And he was told that. He was told, don't testify because you've got prior drug felony, you've got all kinds of problems with you testifying. But his statement, whatever he wanted to say, got into evidence anyway through the officers. He gave a statement, and so whatever he had to say got before the jury.
Well, Judge Valente, if I could address that in just 2 parts, because I think there's 2 different portions there. The first is that there was that colloquy. However, the argument on the ineffective assistance is the advisement that took place between counsel and Mr. Penton, not the...
I understand that. That's why they had a hearing. They had a hearing.
Correct, Judge. But
the found that his attorney was more credible than Penton.
Yes, Your Honor, but well, the credibility part of it, the trial court's actual finding was that this was a strategic decision. The problem is that the strategic decision, I mean, that was an error in that finding because there was no strategy as a part of it. There was a misadvisement. The attorney advised Mr. Penton that, well, there's 2 parts to this. One is it wasn't until the morning of trial that Mr. Penton even knew that he wasn't going to testify. He thought he was going to testify.
Was the prejudice in telling him right before the trial begins that you're not going to testify, assuming he agreed with his counsel? Where's the prejudice?
Well, the prejudice would be the ability to seek counsel that would properly advise him. I mean, he could have been...
The purpose of the colloquy with the court. That's why the judge goes into that detail. Say it's your option. And the judge believes he understood that and decided, okay, I won't testify.
Judge Valente, I think that this court's position should always be that a defendant is going to err on the side of his attorney's advisement versus the standard colloquy.
No, we don't have a position. We have to defer to the trial court's findings of fact as long as they're supported by reasonable, competent evidence. And what you're telling me is I have to believe that no reasonable trial judge would do what this judge did. And I can't believe that. I mean, I was a trial judge for 10 years. You know how many cases I did like this?
Yes, sir.
Hundreds.
Yes, sir.
I don't see this trial judge reacting any differently than any other typical trial judge would react. So you got to sell me on this one.
Sure, absolutely. Well, Your Honor, the holding of the trial court that this court needs to reverse on is that finding of it being strategic. Because of this, the defense counsel testified at the post-conviction relief hearing, testified that he advised Mr. Penton that the details of his convictions would come in, but yet never even prepped his testimony. First of all, that's a misadvisement off the bat. The details of the convictions don't necessarily come in. The second error in that is that defense counsel admitted that he never even prepped the testimony of Mr. Penton. He just assumed, based on what Mr. Penton told him, that he would open a door to all of these other things coming in. So it's not that the trial court erred in doing the colloquy. It's during the post-conviction relief hearing when the trial court heard the discussions that happened between the defense counsel and Mr. Penton, that is not a strategic decision. That is an error by defense counsel. The details don't come in. I mean, that's criminal procedure 101. And prepping your clients in order to make a strategic decision, I would argue, is something that shows deficiency on defense counsel's part.
All right, do what the state says. I understand your argument.
Yes, sure. Thank you. And just to kind of put a cap on that issue of the testimony portion of it, defense counsel was, as a part of that post-conviction hearing, was very candid that the testimony that Mr. Penton was going to offer, and this was in the record on 388 to 391, defense counsel said the testimony that Mr. Penton had would have been very helpful to not only undermine the law enforcement testimony that he was involved, but also the victim testimony who believed that he was involved as well. And again, there's no other defense here other than Mr. Penton or the co-defendants, which I'm about to discuss. So defense counsel's assertion that he had some strategic ability to simply argue the facts here was, I would argue, was not strategic. It was deficient. On the prejudice side of this, which I want to just address briefly for the testimony portion of it, State versus Visger, which is cited to in the initial brief, which is out of the Fourth Circuit, and there's a Foley case under the First Circuit that also follows the same rationale. When the only defense is the defendant, then advising a defendant not to testify, but for some well-articulated rationale, it's reversible error. And that Visger case, I think the court should look to and rely upon in this instance, because that's all there was Mr. Penton being able to say, I stepped away, I wasn't aware of what was going to happen here. And Judge Valenti, I know you mentioned that some of the statements came in anyway, but that fundamental right to testify, it's different hearing it from an officer or a witness than it is hearing it from the proverbial horse's mouth here, hearing it from Mr. Penton. And having that fundamental right, we argue, was denied based on the strategic quote unquote decision. The second portion of this is the co-defendants aspect of it. And Your Honors, I understand that there's a conflict here between the Sixth Amendment and the right to remain silent by these co-defendants. The deficiency aspect here is the failure to pursue, which has to—
Are you talking about the co-defendant that was on the lam, or the co-defendant whose attorney laughed and said, my client's not testifying?
Well, the
co-defendants.
The one attorney that was, or the one co-defendant that had a warrant out for him, according to defense counsel, Mr. Penton had location information on him, never pursued it. As far as the other attorney with the co-defendant, the attorney with the co-defendant with the other attorney, the attorney essentially said, stay away from my client. Mr. Penton's defense counsel's job isn't to abide by that attorney's request, it's to pursue, and maybe nothing would have come of it. But
well, you need to show prejudice. So in other words, let me understand what you're saying. The co-defendant that was on the lam, he might have been found had defense counsel been more rigorous in his search. But there's no evidence to show that even if he was found, he would have said, okay, I'll inculpate myself and testify on behalf of Penton. I mean, it's kind of ludicrous to think any co-defendant's going to say, okay, this guy had nothing to do with it, it's all on me, even if they waive their Fifth Amendment right not to incriminate themselves.
Well, Your Honor, there is sworn testimony in the record from Mr. Penton and the defense counsel backed this up, that he informed him that the co-defendants had information that would exonerate him, that they would back him up on this. Now, whether that's true or not, that's fine, but that was a sworn affidavit in the record as a part of the post-conviction hearing. Also, Judge, is it more common for a co-defendant to testify against their co-defendants? Absolutely. Yeah,
but that didn't happen in this case.
Well, that didn't happen, but we don't know what would have happened here. In the state's answer brief, their response to this argument was essentially any sort of immunity or anything on that spectrum would have to be approved by the state, and that is essentially a laughable premise. Having been a state attorney, having done enough of these cases, I'm assuming that if those co-defendants had at least, if they had come forward, if they had been pursued, that I don't think it's a laughable premise that the state may have found some sort of consideration in the idea that two of the co-defendants are saying that, yeah, that he wasn't a part of this. Maybe it would have happened, maybe it wouldn't, but the lack of investigation, and I'd like to point the court to a couple of key phrases here. Defense counsel Watson said that he never even considered it, that it was new to him. He was floored by the thought of it. And then one of my favorite quotes of his is that it was due to his lack of imagination that he didn't pursue these co-defendants. The defense counsel—
You got any cases that say that's enough? What cases are you relying on to say that's enough to get this guy a new trial?
For the purposes of pursuing of the—
Anything of what you're saying. You're making a lot of good arguments, but I don't hear case citations.
Judge, yes, Your Honor. So I'm just, it's a little different referencing the video and my notes here.
Sorry about that.
So and these are all cited to in the initial brief.
Well, I could look it up. If you can use that, I could look it up phrase if you want. That's fine.
Well, and I'll point you to a couple of here, Judge. That Visker case is one that deals with the idea that the sole defense is an important factor here. But I mean, more importantly, as a part of it, setting aside the whole basic Strickland analysis, we cite to Tyler versus State, we cite to Henry, both of which deal with this idea that the failure to do something, i.e. pursue witnesses, which is, here we go, Beasley versus State, Judge, the Florida Supreme Court, 18 Southern 3rd 473. The whole basis for the trial court's decision, again, was strategy. That was what the trial court held, that the witnesses were unavailable and that any decision to not pursue them was, or the one witness, excuse me, the one co-defendant was unavailable. The other was strategy on behalf of defense counsel. With all due respect to the trial court's ruling here, when a defense counsel says under oath, this was a novel idea to me, I didn't even look into it, that can't be strategy. All of the strategy precedent says that there has to be a thoughtful analysis and a decision made. There was no decision. This attorney said that it was completely new to him. So that concept alone, a failure to pursue, is enough to establish a deficiency and prejudice. I don't disagree with the state of Florida's assertions in their answer brief that maybe the co-defendants wouldn't have come forward, maybe they would have, but we know the only sworn testimony in this record, and defense counsel supports it, is that Mr. Penton had locations and had information that these co-defendants would provide exculpatory information for them. Your Honors, again—
I'm sorry, Mr. Martina, I just wanted to follow up on this discussion of strategy.
Yes.
So what I'm hearing you argue is that it couldn't have been strategy based on counsel's comments. Are you also arguing, refresh my memory, that, you know, even if it was strategy, it wasn't reasonable? Because, you know, strategy is only, I mean, it has to be reasonable.
Yes, absolutely. So on the first issue of him testifying, I think reasonableness has to factor in as a part of the equation. It wasn't reasonable if the court looks at the Visker analysis, which says if this is the sole defense, which it was, Mr. Penton was essentially the sole defense. I'm sorry, Judge.
That's the Fourth Circuit case that you referred to earlier, correct?
Yes, yes, Your Honor, it is. On the second portion of it, dealing with the co-defendants, Reasonableness always factors in, but frankly, Judge, I didn't make a reasonableness argument in the brief with the second portion of it because there was no justification given by the defense counsel. Had there been any justification, then reasonableness would factor in. So on the first one, Judge, I would say it's not reasonable because, again, that Visker is pretty clear that the attorney has to show something more than just, well, I thought it may have gone either way. And then on the second one, the only justification was, this is completely new to me. I'm floored by it, which
is not a strategy.
Which is not a strategy, Judge. It is a deficiency. And there should have been somebody in that post-conviction hearing that could have said, Judge, these were the paths I beat down. I beat it down to try to get those co-defendants. I wasn't able to do it. And I know.
Okay, Mr. Martino, you've got your 4 minutes left. If
Yes.
you want to save them. All right. Thank you.
I will reserve the rest for rebuttal, Your Honor. Thank you.
Counsel, when you're ready.
May it please the court, counsel. My name is Lori Benoit Knox and I represent the state of Florida in this matter. I want to take a step back from everything that was just discussed and talk about the burden of proof. This is a motion pursuant to Rule 3.850. In subsection F8B, the rule reads, at an evidentiary hearing, the defendant shall have the burden of presenting evidence and the burden of proof in support of his motion. In this case, the motion itself, even if it has an oath, cannot be the support for the motion. Appellant did not take the stand at the hearing, did not present any evidence, did not reduce any testimony, did not call any witnesses. Therefore, the only evidence that was in front of the post-conviction court was the testimony that was elicited from Attorney Watson. Attorney Watson did not admit that he had misadvised his client about his right to testify. What he said was that he did not make the decision, that he allowed the defendant to make the decision, but that he advised him that he believed that the benefits were outweighed by the prejudice, considering the fact that the jury would have heard that appellant was a multiple-time convicted felon and that Attorney Watson expressed concern that in testifying about his roommates, co-defendants, robbing the victim because they were high on drugs, appellant could open the door to his own convictions, to the substance of his convictions or his own drug abuse generally. That was a legitimate concern.
Now let me ask you a question. That's correct, right? That's
Yes.
black letter law. That would open the door to the convictions, not necessarily the details of each of those convictions, correct?
Correct. But in testifying that the reason that his roommates had robbed the victim was because they were high on drugs, depending on the phrasing, depending on what would have been said, there is a chance he would have opened the door to more than just the fact that he was a multiple-time convicted felon.
All right. And then my other question is the lack of imagination. The concept was new. The attorney said, in context, the way I took that, the concept was new or a lack of imagination. I would never dream that a co-defendant would inculpate himself in favor of another defendant. That concept was new. That just doesn't happen, as opposed to, I'm not tracking this guy down, I'm not doing more. Is that
correct?
I mean, context matters in this case. We can take it out of context and make it look like we're dealing with an incompetent attorney, but we really weren't.
No, we were not.
The judge didn't make that finding. I mean, Watson did testify that they made reasonable attempts and no one questioned him. Well, did you go here? Did you go to there? Did you do this? Did you do that? Nobody questioned him. He just said, hey, we tried to find him. We couldn't find him.
Correct.
All right. I want to just make sure. I mean, the argument I'm hearing is Watson could have done more. There's nothing on the record to show exactly what he did, but no one questioned, hey, tell me exactly what you did. He doesn't have to take. He can go to the conclusion if he wants to, and the judge can take it for what it's worth, and the judge did. That's not much of a question, but it's a comment.
I agree, Your Honor. Nobody especially asked him that. And again, it wasn't the state's burden to prove that he hadn't done enough. That was appellant's burden. Those questions weren't asked. Just like he wasn't asked how many times, not that that was preserved for appeal, but he wasn't asked how many times he had consulted with appellant. None of that was asked. We don't have the benefit of the tone of his comments when he says that was a novel concept. It's unclear whether he was being sarcastic. I don't know, but appellants simply did not meet their burden. And I think even, you know, my colleague's words, when my colleague says, you know, it may not have been successful, well, that in and of itself shows that appellant cannot show prejudice. Even if we got over the deficient performance bump, which the state absolutely asserts that we don't, but even if we did, we cannot get to prejudice. Appellant has simply not met his burden by presenting no evidence. And so for these reasons, the state would ask that you affirm the conviction. And if there are no other questions, I would rely on the merit of my brief.
Thank you.
Okay, thank you. Mr. Martino?
Yes, Your Honor, thank you. Just to address that portion at the end there, Judge Valenti, about the record, I won't, because I don't have the time to do it, of course, I won't take the court's time to read the entire record, but if the court goes to page 392 and 393, Judge Valenti, I think if you read that discussion between or of defense counsel during the post-conviction hearing, the context is important because when Mr. Penton says to him, why haven't you talked to these witnesses? And he realizes they're the co-defendants. That is when defense counsel says, I was floored by it. I never even thought of that. So I think looking at 392 and 393 in the record will provide the context that is important to what we're doing here, which is my colleague there said that, well, maybe nothing would have happened and that proves it, but that's not the case. Your Honor, before I was looking for the Tyler case, which is out of this court, which deals with questioning witnesses. And the test for that, and of course now it went away again on me, but this court in Tyler said, appellant's identification of the witnesses or witnesses, which he did, the substance of the witness's testimony, which he provided to defense counsel testified to at the post-conviction hearing, and a description of the prejudice suffered. Defense counsel said that the only defenses here were Mr. Penton or the exoneration by the co-defendants. So there is an issue here with this defense counsel not pursuing these witnesses. And I just want to touch on a couple of the other items. Let's see, that the preparation on May having opened the door, I would just point the court back to the idea that defense counsel admitted that he never prepped the testimony of Mr. Penton. How can he know? And my colleague is absolutely correct that maybe the door would have opened. You can't really be sure unless you prep your clients. And then you advise them on that and then you move forward. Defense counsel here did not do that. These arguments are always difficult because I always feel like sometimes it feels like you're backseat driving, you're backseat practicing, right, with these attorneys. But the statements of defense counsel here should ask this court, I would ask this court that based on those statements, based on what happened here, the court reverse and remand for a new trial to allow Mr. Penton to testify and present a defense that he was entitled to in the first place. With or without co-defendants, he had a right to testify. He was told the details of his past would come in, and that was deficient, and that prejudiced him. Your Honors, if there's no other questions, then thank you for your time.
Thank you.